Case 45, Eastern Airlines versus Floyd. We find ourselves at the Supreme Court of the United States. Facts. On May 5, 1983, an Eastern Airlines flight departed from Miami, bound for the Bahamas. Shortly after takeoff, one of the plane's 3 jet engines lost oil pressure. The flight crew shut down the failing engine and turned the plane around to return to Miami. Soon thereafter, the 2nd and 3rd engines failed due to loss of oil pressure. The plane began losing altitude rapidly, and the passengers were informed that the plane would be ditched in the Atlantic Ocean. Fortunately, after a period of descending flight without power, the crew managed to restart an engine and land the plane safely at Miami International Airport. Respondents, a group of passengers on the flight, brought separate complaints against petitioner Eastern Airlines, each claiming damages solely for mental distress arising out of the incident. The district court entertained each complaint in a consolidated proceeding. Eastern conceded that the engine failure and subsequent preparations for ditching the plane amounted to an accident under Article 17 of the Convention, but argued that Article 17 also makes physical injury a condition of liability. Relying on another federal court's analysis of the French authentic text and negotiating history of the Convention, the district court concluded that mental anguish alone is not compensable under Article 17. The Court of Appeals for the 11th Circuit reversed, holding that the phrase lésion corporelle in the authentic French text of Article 17 encompasses purely emotional distress. To support its conclusion, the court examined the French legal meaning of the term lésion corporelle, the concurrent and subsequent history of the Convention, and cases interpreting Article 17. So what's the issue? The court needed to resolve a conflict between the 11th Circuit's decision in this case and the New York Court of Appeals decision in Rosman, which held that purely psychic trauma is not compensable under Article 17. The holding. The court held that Article 17 does not allow recovery for purely mental injuries. Reasoning. The court noted that under Article 17, an air carrier is liable for passenger injury only when 3 conditions are satisfied. Number 1, there has been an accident, in which, number 2, the passenger suffered mort, blessure, ou toute autre lésion corporelle, and, number 3, the accident took place on board the aircraft or in the course of operations of embarking or disembarking. As the airline conceded, the incident here took place on board the aircraft and was an accident for purposes of Article 17. Moreover, the passengers conceded that they suffered neither mort nor blessure from the mishap. Therefore, says the court, the narrow issue presented here is whether, under the proper interpretation of lésion corporelle, Condition 2 is satisfied when a passenger has suffered only a mental or psychic injury. In finding that the signatories' post-1929 conduct supports the broader interpretation of lésion corporelle, the Court of Appeals relied on 3 international agreements: the Hague Protocol of 1955, the Montreal Agreement of 1966, and the Guatemala City Protocol of 1971. For each of these agreements, the Court of Appeals emphasized that English translations rendered lésion corporelle as personal injury instead of bodily injury. In the Supreme Court's view, however, none of these arguments support the broad interpretation of lésion corporelle reached by the Court of Appeal. The Hague Protocol amended Article 3 of the Warsaw Convention, which sets forth the particular information a passenger's ticket must contain to require notice of the limitation upon the carrier's liability for passenger injuries under the Convention. While the authentic French version of Article 3 retained the phrase lésion corporelle, the authentic English version of the Hague Protocol, which was proposed by the U.S. delegation, used the phrase personal injury. The Supreme Court rejected the argument that the Hague Protocol signatories intended personal injury to be an interpretive translation of raison corporelle, where there is no evidence that they intended the authentic English text to suffer a substantive change in or clarification of that term. Moreover, the portion of Article 3 of the Hague Protocol in which personal injury appears is concerned solely with informing passengers that when the Convention governs, it, in most cases, limits the liability of carriers for death or personal injury. It may be, therefore, that the signatories used personal injury not as an interpretive translation of raison corporelle, but merely as a way of giving a summary description of the limitations of liability imposed by the Convention. The Montreal Agreement of 1966 was similarly inconclusive, according to the court. The agreement, which affects only international flights with connecting points in the United States, raised the limit of accident liability to $75,000 and waived due care defenses. The Court of Appeals noted that under the Montreal Agreement, the notice appearing on passenger tickets used the term personal injury rather than bodily injury, and that the United States Civil Aeronautics Board used these terms interchangeably in approving the agreement.